Good afternoon, everyone, and welcome to the 2016 webcast on promoting better legal practices, an initiative of the Law Society's compliance-based entity regulation task force. Thank you for joining us. My name is Margaret Drent. I am Policy Counsel at the Law Society, and I will act as chair this afternoon. Our presenters today are Treasurer Janet Miner on my right, Ross Earnshaw, bencher of the Law Society of Upper Canada and chair of the task force, Raj Anand, who is seated to the left of Gavin McKenzie, bencher and task force member, and Gavin McKenzie, former treasurer of the Law Society of Upper Canada and member of the task force. Materials, including a call for input paper, are available for your review on the Law Society's Better Practices dedicated webpage, which may be found at lsuc.on.ca/better-practices or meilleure pratique en français. There will be an opportunity for you to ask questions throughout the webcast, and we've also saved some time at the end of the presentation for questions as well. You will see a Q&A tab on your screen, which will allow you to submit questions to us. This is a bilingual webcast. Participants who wish to ask questions in French may do so using the Q&A tab on their screen. Cette web émission est bilingue. Les participants qui désirent poser des questions en français peuvent le faire en cliquant sur l'onglet Q&A sur leur écran. I would now like to invite Treasurer Janet Miner to introduce our session.
Thank you, Margaret, and good afternoon, everyone. Merci et bon après-midi à tous et à toutes. I understand that we have almost 1,000 people registered for this webcast, including those from other provinces. Thank you for joining us. This session has two main purposes. First, this is an opportunity for us and the task force to provide you with further information about promoting better legal practices and our initiative looking at compliance-based practices and entity regulation. Secondly, we have published on our website a discussion paper, and we very much want to encourage you to participate in this consultation and express your views on the questions that are raised there. Before Ross provides more detail on the topic of our session, I want to comment briefly on why this initiative is important. As part of our strategic priorities, the Law Society is committed to being a leading regulator. In support of that goal, we monitor changes in the legal landscape, in the regulatory landscape, and in the legal services marketplace. To this end, last June, we established a task force to look at compliance-based entity regulation. Compliance-based models are proactive and focused on fostering better practices. They're based on encouraging and supporting improved practice management by the regulator. We would set certain goals, and we would provide assistance as needed to assist law firms and legal practices to meet those goals in the way that would best suit the individual firm or the practitioner. We understand that if compliance-based regulation is introduced, one size would not fit all. And the possibility of developing a regulatory framework that would provide a great deal of flexibility and autonomy to lawyers and paralegals is important to us. As practitioners, you will know there's a considerable transformation taking place as a result of developments in technology, globalization, and downward pressure on costs. We see the results of some of those pressures in our day-to-day work here at the Law Society. Half of the complaints received by the Law Society in 2014 concerned client service and other areas relating to practice management. In this context, proactive management could include looking at those issues, for example, improving communication between the legal practitioner and the client. There's some evidence from other jurisdictions that this approach to regulation may assist lawyers and paralegals in improving their practices and client service. This approach could encourage practitioners to think about certain practice management issues up front rather than responding after the fact. Another factor that we observe in the environment in which we practice is that the environment is much more important than it used to be when the regulatory system was initially designed. Although we regulate individuals, we know that in many cases, organizational culture determines how competently and how ethically a lawyer or paralegal practices. It's been suggested that culture is to a group what personality is to an individual. By focusing on how the entities that provide legal services organize and manage their practices, lawyers and paralegals could experience better outcomes as participants in the administration of justice. I'd like to emphasize that we're very much in an exploratory phase. We're looking at a wide range of potential models. No decisions have been made as to whether or not to proceed, or if we do, exactly how we would proceed. We'll benefit immensely from your input, hearing your perspectives on what may or may not work in your individual practice environments. I'd like to turn now to Ross Earnshaw, who will provide an overview of the issues we're going to discuss this evening. As Margaret said, Ross has been a bencher of the Law Society since 2011 and chairs the Law Society's task force on compliance-based entity regulation.
Thank you, Treasurer, and welcome everyone to today's webcast. I thought I'd begin by providing a definition of compliance-based entity regulation, and I propose to do that by breaking it down into its component parts. So dealing first with compliance-based regulation, as the Treasurer mentioned, this is a proactive approach to regulation. The regulator, the Law Society, identifies practice management principles and establishes goals, expectations, and tools in demonstrating compliance with these principles in practice. This approach recognizes the increasing importance of the practice environment in influencing professional conduct. Lawyers and paralegals would report on their compliance with the expectations and would have flexibility in deciding how to meet them. For example, the Law Society may set an expectation that a practitioner or firm have practices in place to ensure client confidentiality, but would not stipulate exactly how this would be accomplished. The firm would be free to establish a process or policies that would work best for it. Turning to the second component of the definition, entity regulation, this refers to the regulation of the entity or firm through which lawyers and paralegals provide services, and it may include sole proprietorships. Many professional conduct decisions that were once made by an individual lawyer are now determined by law firm policies and procedures. The environment in which a lawyer or paralegal works plays an increasingly significant role in determining an individual's professional conduct. So putting it all together, compliance-based entity regulation refers to the proactive regulation of the practice entity through which professional legal services are delivered. The phrase promoting better legal practices summarizes what we seek to achieve. This is all about creating a culture to foster better practices. Building an ethical infrastructure is another way of looking at it. Ethical infrastructure is a term which refers to the workplace culture, policies, and procedures within a firm that help practitioners fulfill their ethical and professional duties. It could include, for example, procedures regarding the documentation of conflicts of interest checks and guidelines for communications. Again, lawyers and paralegals would have flexibility and autonomy in determining what those frameworks might look like.
Thank you, Ross. I would now like to invite Raj Anand, bencher of the Law Society since 2007, to describe why the Law Society believes there's merit in exploring this type of regulation.
Thanks very much, Margaret, and good afternoon, everyone. Bon après-midi, tout le monde. Based on its research and the experience in other jurisdictions, the task force believes that there may be a number of benefits for both the public and practitioners that would flow from a compliance-based approach to regulation. Adopter une réglementation fondée sur la conformité pourrait s'avérer avantageux sur plusieurs plans. Number one, focus on improving the management and culture of the firm as a whole, which would promote both the ethical best practices of the firm and the lawyers and paralegals associated with it. Premièrement, la mise en œuvre d'une réglementation proactive aurait un effet bénéfique sur la gestion et la culture des cabinets dans leur ensemble. Number two, recognition that the firm has a role to play in promoting the ethical conduct of lawyers and paralegals. Deuxièmement, les cabinets ont un rôle à jouer pour favoriser les comportements conformes à l'éthique des avocats et des parajuristes. Number three, reduce complaints. Practitioners would be encouraged to consider how practice management issues might be avoided rather than reacting to problems after the fact. Troisièmement, on peut mettre en œuvre des systèmes internes pour réduire le nombre des plaintes au barreau. Fourth, flexibility and autonomy to develop internal systems and processes that work for the individual practitioner or the firm. Quatrièmement, on peut donner aux praticiens une autonomie leur permettant d'élaborer des processus adaptés à leur entité. Fifth, better protection of the public and enhanced public confidence in the law society. Cinquième, mieux protéger le public. And sixth, the Law Society might be able to respond to new issues as they arise without having to create new rules. Sixième, le barreau pourrait réagir aux nouveaux problèmes sans avoir à créer de nouvelles règles. During the course of our work here in Ontario, we've held a number of discussions with representatives of other Canadian law societies who are considering these issues, some of whom are with us today. In addition, we've also looked at other jurisdictions that have implemented these changes. Au cours de notre travail, nous avons discuté avec les représentants des autres barreaux canadiens qui se penchent sur ces questions. Certains d'entre eux sont avec nous aujourd'hui. De plus, nous avons observé les autres ressorts qui ont fait ces changements. Research conducted in Australia reveals that when practitioners are obliged to reflect on aspects of their practice up front, they are less likely to receive a complaint. Complaints in New South Wales declined by 2/3 after it became mandatory for a practitioner to consider certain key practice management principles and how they had implemented them in their practice. In the consultation paper, the task force asks for input on the potential benefits of this initiative. We are also interested in knowing what challenges lawyers and paralegals think they might face with this type of regulatory approach. We look forward to receiving your input.
Thank you, Raj. And I would now like to invite Gavin McKenzie, former Treasurer of the Law Society of Upper Canada and a bencher since 1995, to explain how this approach to regulation might work.
Thank you, Margaret. Very briefly, this is how this type of system might work. Practitioners would be required to consider principles, which I'm going to describe in a moment, and the extent to which they have implemented those principles in their practice. The principles that we are considering are 7 in number. First, practice management. Second, client management. Third, file management. Fourth, financial management and sustainability. Fifth, professional management. Sixth, equity, diversity, and inclusion. And finally, access to justice. And let me just take a few moments to explain each of those briefly. Practice management refers to the supervision of the practice, the practitioners in it, and staff to ensure the competent delivery of legal services. Client management refers to practices that prevent conflicts of interest, ensure effective client communication and management of client expectations at each stage of the matter. File management refers to consistent opening and closing of files, as well as practices to ensure the physical integrity and confidentiality of the file. Financial management and sustainability refers to business planning and budgeting, ensuring that the entity manages its finances appropriately, considers insurance needs, and adopts business continuity, succession planning, and wind-down plans as appropriate. Professional management refers to the entity's support of practitioners to stay current in their chosen practice areas, to build capacity in new practice areas, and to maintain collegial relationships in the profession. Equity, diversity, and inclusion refers to policies that ensure a respectful workplace environment that accommodates diversity, inclusion, and disabilities. And finally, access to justice, of course, refers to the entity's role in improving the administration of justice and enhancing access to legal services.
Thank you, Gavin. I have a question for Ross, and my question is whether these principles would apply to law and paralegal firms in the same way.
In a word, no. As the treasurer said, this is not about one size fits all. In the discussion paper, which is on the website, as you pointed out, we ask a series of questions about the application of compliance-based entity regulation to different categories, including a sole practice, a small firm, a medium-sized firm, a large firm, and a national or international firm. We also ask practitioners for their thoughts on the considerations that should be kept in mind that would be particularly applicable to a sole practitioner or a small firm. Having previously worked in a small firm myself at the beginning of my career, I recognize that a sole practitioner would experience these changes differently than would a lawyer or a paralegal in a larger firm. We welcome the input of the profession on this point as well. And I would like to take this opportunity to emphasize that the Law Society would make resources and practice supports available to assist practitioners who have questions or need help to implement these changes, something which I think is particularly important to the solo practitioners and small firms.
Thank you, Ross. I have a question for Raj, and my question is whether practitioners would report to the Society on their compliance with the principles.
Thanks, Margaret. An option that the task force is considering is whether a lawyer or paralegal should be designated in each case by the entity to have particular responsibilities. This is what is referred to as the designated practitioner in the paper. The designated practitioner's responsibilities could include the following 4 points. Les responsabilités d'un praticien désigné pourraient comprendre ces 4 aspects. First, reporting on the implementation of the practice management principles. Déclaration de la mise en œuvre des principes de gestion de la pratique. Second, communicating with the Law Society to confirm that the entity is in compliance with the principles. Confirmer au barreau que l'entité s'est conformée aux principes et continue à le faire. Third, the designated practitioner could receive complaints about the entity. Troisièmement, la réception des avis de plainte. And fourth, the designated practitioner could be the one who reports about trust accounting matters and ensures that the firm's record keeping is current. Quatrièmement, les déclarations liées au compte en fiducie et veiller à ce que la tenue des dossiers soit à jour.
Thank you, Raj. I now have a question for Gavin, and I'm wondering if Gavin might tell us to whom the practice management principles would apply. Would they apply only in private practice?
The consultation paper suggests that private practices would be the starting point. If Convocation were to approve this form of regulation, we may then look at expanding it to in-house counsel and practitioners in government and legal clinics. And there would be additional consultation regarding the application of this form of regulation to those areas where if Convocation is to approve the regulation in this form for private practices.
Thank you, Gavin. I now have another question for Ross.
Further, reducing complaints. As the Treasurer indicated in her opening remarks, this is about putting a greater emphasis than is currently the case on a proactive approach to regulation. The focus of this proactive approach is the enhancement of practice standards. That is the ethical infrastructure that I mentioned earlier.
Thank you, Ross. How will the Law Society monitor compliance? This question has to do with what would happen if a practitioner indicated to the Society that some or all of the principles had not, in fact, been fully implemented in their practice. And I would like to invite Raj to comment on this question, please.
Thanks, Margaret. The Law Society's response would likely depend upon the nature of the issue. The Law Society might contact the entity or the designated practitioner that I spoke of a moment ago to discuss the issue and whether the policies and procedures of the entity might be improved. In the paper, we refer to the phrase continuum of regulatory responses. At the other end of the continuum, of course, the entity could be investigated or disciplined. The task force looks forward to submissions on this point. Le groupe de travail attend vos mémoires avec anticipation sur ce point.
Thank you, Raj. Well, one question that I had was that the practice management principles sound very familiar, and I was wondering if any of you could comment, perhaps you could begin, Raj. Why did the task force identify these principles in particular?
Well, as Ross mentioned, the Law Society has already implemented a number of proactive initiatives, such as practice review for lawyers, practice audit for paralegals. Practitioners selected for these programs are asked to reflect on their practice by completing a checklist before the audit. In developing the principles that are included in our consultation paper, the task force reviewed this checklist. The task force also looked, and this is set out in the consultation paper, at other jurisdictions, including Nova Scotia, England and Wales, various Australian states and territories, and the principles that we've suggested and that have been adopted both in Canada and abroad are very similar.
Thank you, Raj. What are the next steps for the Law Society in considering this initiative? Gavin, I wonder if you might comment on that.
We're asking for responses to the consultation paper by the 31st of March, and the task force will be considering all of the responses it receives and preparing a report to convocation in the spring.
Thank you, Gavin. Well, we, as indicated at the outset, we're offering an opportunity to participants to ask any questions, and I would like to invite anyone who does want to ask any questions to send them to us at this time. Vous pouvez également poser des questions en français. Well, we might just give people a few moments to perhaps reflect on what they've heard. Perhaps one point that might be of interest is the reaction that's been received so far as you've been out, Treasurer, in your many opportunities for outreach with members of the profession. Is there anything you've heard in particular in terms of how, for example, these changes might be received by members of large national firms?
One question that I've been asked is, would the Law Society have a system or a proactive system that would be different from other provinces, so that a national firm would be looking at compliance with a number of different systems, which would of course create a certain amount of confusion and difficulty. And we're very aware of the need to have some type of consistency as this, assuming that this particular method evolves across Canada. We've been in touch with other provinces, and we certainly want to ensure that we would go ahead on the understanding that firms need to have some consistency in what they are complying with.
Thank you, Treasurer. Well, I wondered if other members of the task force might want to comment on any feedback that's been received, for example, from sole practitioners or small firms.
I see that there are some questions.
That's fantastic.
I might just raise one of them, which I'm sure you can answer very easily, and that is it mandatory for lawyers to participate in sending responses by March 31st, 2016? The chair can address that.
Yes, the reason for setting the March 31st deadline is that the mandate of the task force requires that we report back to convocation with our the results of our endeavors by May of this year. And if we are to meet that timeline and make a meaningful report, it's essential that we have the input from the professions to guide our deliberations. We have a series of meetings scheduled over the next couple of months with a view to assimilating the information that we anticipate receiving as a result of this request for input. And it's vital that we meet that deadline in order to be able to complete our report. That's why March 31st. So never say never. It's not written in stone, I suppose, Raj, but it's certainly one that we have to live with if we're going to make a meaningful report and get the input that we're looking for from the professions.
Thank you, Ross. We have another question that I wondered if I might direct to Gavin, and that is, why is it the case that in-house counsel and government lawyers are not included in this initiative at the moment?
I think that's a very good question. There are complications that present themselves insofar as in-house counsel and government lawyers are concerned that don't present themselves as far as lawyers in private practice are concerned. So the view of the task force is that should we adopt this for lawyers in private practice, we should incrementally look at lawyers in other practice settings. Just to give one example that we've discussed on the task force, it's one thing, it seems to us, if we have a law firm in private practice that is an entity that we're regulating and that we can expect to adopt these principles and report on their implementation. It's another thing if a lawyer works for an organization such as a large public company. We don't presume and don't expect to ever be in the position to regulate large public companies. So they wouldn't be defined as entities for our purposes. Having said that, we think it's highly desirable that should Convocation adopt this approach for lawyers in private practice, that lawyers in an in-house setting also adopt these principles. Their implementation would undoubtedly differ in that kind of a practice setting, but we think it's best to take this incrementally, one step at a time.
Thank you, Gavin.
I wonder if I might just add to that, Margaret, a thought or two. As Gavin has explained, the discussion paper doesn't call upon practitioners outside private firms to respond at this time, and indicates that there would be a further consultation before we would incrementally implement a proactive system to them. But I want to emphasize that we're still looking for input from these people in these other practice settings, because we are talking about the principles that would apply to the compliance-based aspect of the system. And so I wouldn't want them to think there's no need to provide input only to find that principles had been adopted or put in place that they might have difficulty with. So it's important that we get feedback from all professionals, paralegals, lawyers, every practice setting.
And a lot of the principles, ethical principles, will be common. Some will certainly be different in different settings. But it would certainly be useful to get that input. I agree with you.
Thank you.
Thank you very much. We've got lots of questions, which is excellent, so we'll try to get to as many of them as we can. And we perhaps should have indicated at the outset that if we're not able to cover all of the questions this evening, participants are more than welcome to send their questions by email after this evening's session. I wondered if I might ask you, Treasurer, to comment on this question, which was, what would be the recommendation as to the date on which these changes might be implemented? And I wondered if you had any thoughts on that.
Well, that will be one of the recommendations we'll be looking to the group to advise, and we would have to take into account what the implementation requirements are, both for the Law Society and for the various workplaces. So certainly there'll be some lead time. I don't think we have any magic date in mind at the moment.
Thank you, Treasurer. I wondered if, Ross, I might ask you to comment on this question, which has been raised by a member of the Law Society who indicates that he is a sole practitioner who does not have the benefit of any staff and finds that it's already quite onerous to comply with current regulations, which in some cases he feels take him away from his practice. And he's asking, how does the Law Society plan to help those practitioners who are in that position? And I wondered if you might comment.
Well, first of all, one of the questions that's asked in the discussion paper is whether the entity regulation aspect of the proposal ought to extend to sole practitioners and small firms or not. So the sort of thought process that underlies the question is something we want to hear about from the profession. But as I have reviewed the various materials that the task force has looked at, some of which we've discussed this afternoon, I have seen that wherever this kind of proactive system is put in place around the world, there is a shift in thinking. There is a relationship change between the regulator and the regulated, between the law society and the practitioners. And that's what I would like to emphasize. I mentioned it earlier in response to one of the questions that you asked. That is that there would be assistance provided, tools provided by the Law Society to assist. And so this should not be seen, in my respectful view, as an additional regulatory burden, but an opportunity to improve practice management, to improve some of the issues that led to the question in the first place. That with better practice management, better tools of the trade, as it were, sole practitioners and small firms might well benefit by having a more efficient practice, a happier clientele, fewer or no complaints, one would hope, and dare I say it, a better bottom line as a result. And so it ought not to be seen as a regulatory burden. It ought to be seen as a chance to change the relationship between the Law Society and the professionals to one of assistance and helpfulness rather than sort of reactive disciplinary approach.
Thank you, Ross. I wonder, did you want to comment on that, Gavin?
Yes. I think there are two aspects to the mandate of the task force. One is the entity regulation, and one is the compliance feature of it, or the proactive feature of it. And I think the question of why have it apply to sole practitioners is a good one. Historically, we were set up to regulate at a time when virtually all lawyers in private practice were sole practitioners or in very small firms. We've now evolved to the point where we have so many different kinds of practices. They're much more specialized. We have large national and indeed international firms that require regulation in quite a different way. So the question is, well, why have entity-based regulation for a sole practitioner when the sole practitioner is an individual with no employees? The other half of the equation, though, is the proactive or compliance-based feature of it. And I see that as analogous to preventive medicine. It's better to eat properly, work out, and stop smoking rather than go in for an operation and have chemotherapy for lung cancer or some other cancer. And I think I would see this kind of regulation as more of a benefit than a burden. That isn't to say that we wouldn't be taking time out of the lives of sole practitioners and small firm lawyers to consider the principles and decide how they would be implemented. But in the case of a small practitioner, it would be very, very different than in the case of a large firm. In a large firm, it's very important, for example, that we have quite a detailed practice relating to equity and diversity. In a sole practitioner's firm who has no employees, the plan could be very simple, and the implementation could be non-existent. On the other hand, I think the sole practitioner could well benefit by directing his or her mind to the practice management principles, the financial sustainability principles, etc.
Thank
Can
you.
I just add something to that? And that is that, I mean, we know, and the paper refers to the fact that small firms and sole practitioners are disproportionately found in the discipline and the regulatory system. And that may be because of factors that are endemic to them, that are characteristic of them, such as the lack of a person down the hall to get input from, the lack of a number of different ideas on systems being put in place. And so with the assistance of the Law Society, I think the goal is to help to put in place policies and practices, which, as both Gavin and Ross have said, will avoid complaints and avoid practices which could potentially result in complaints, because they are certainly they're certainly costly to the practitioner. They're costly to the law society. They're not helpful to clients. And the goal here is to improve practices in a cooperative way, rather than spend the time and the energy and the cost in dealing with things ex post facto.
Thank you, Raj. So those comments perhaps tie in with this next question that I was going to actually ask you to comment on, if I may. And the question is, will guidelines and templates be provided to assist a firm in setting up its policies and procedures for compliance?
I think that's certainly the intent, that if the initiative goes forward, the goal is going to be to provide tips, guidelines, assistance, so that because a lot of the problems are clearly common to certain sizes of firms and can be used by a variety of different firms, and why should every one of them be required to rediscover the wheel? At the same time, they'll have the flexibility and autonomy, as Ross was saying, to adapt it to their own circumstances. So I think the answer is yes. If this initiative goes forward, certainly we will be looking at that in terms of a go-forward initiative.
Thank you, Raj.
I wonder if I might just jump in on that one.
Yes, of course.
If I could. The paper speaks of two examples of what is called a self-assessment tool. One of them is homegrown. It's the CBA Ethical Practices Self-Assessment Tool. And the other that's briefly mentioned is one that is under study in Nova Scotia by the Nova Scotia Barristers Society. And they call theirs, I always have to look this up, Management System for Ethical Legal Practice Self-Assessment Tool. And in both of those examples, both of which were studied along with some examples from the UK and Australia by the task force, there are a series of principles which are enunciated by the regulator. And then the self-assessment tool allows this flexibility and autonomy that Mr. Anand was speaking of in meeting those principles and objectives, and provides examples, guidelines, templates as to what it might look like, without saying it must look like anything in particular, as long as the principle is met. And so one could describe it, I suppose, as a template, but it's certainly a series of helpful suggestions. And in the case of the Nova Scotia Barristers Society, it's actually, their self-assessment tool is actually, sorry, I'm a technical dinosaur, but I think it's called hot-linked. It's hot-linked to articles and helpful treatises written not only by people in Nova Scotia, but accessed around the world. Indeed, much like the bibliography to our own discussion paper. For anyone who wishes to read further, there's lots written on it, and the bibliography provides a good deal of additional information.
Thank you, Ross. Well, in fact, I think that response that you just provided to some extent may address a concern that was raised by one of our participants this evening, who asked whether the Law Society of Upper Canada had considered the proposed Nova Scotia model in its deliberations, and was the Law Society of Upper Canada taking into consideration concerns that were expressed in that jurisdiction, where, according to the participant, some have expressed the view that the detailed reporting that may be required could be quite onerous. And there were some concerns as well about the cost that could be associated with compliance.
I'm not so sure how current the questioner is on the status of the progress in Nova Scotia. That sounds like a comment that was based on an earlier version of the self-assessment tool, which was considerably more onerous. The most recent iteration, the one that is now being subjected to feedback in Nova Scotia, is one which is much more like I described a moment ago, where I believe they have 10 principles. The 10 principles are established, are set out. A number of suggested options or templates or examples are given. There is, as I said, a link to helpful literature. But all that's really required by the designated professional in that jurisdiction, if they go ahead with the plan as presently designed, is to indicate that the firm actually meets that objective. And then there's an option to provide further comment or request for assistance. So it's really not particularly onerous at all in the present iteration. Does that help?
Thank you, Ross. Absolutely. And I wondered if I might now turn to the Treasurer and ask the Treasurer if she could comment on this next question, in which the participant has suggested that the consultation paper really seems to focus on the benefits of compliance-based regulation. And the participant is asking whether the benefits of entity regulation have been taken into consideration by the Law Society, since, according to the participant, there isn't as much focus on that in the paper.
Thank you. I think that the benefits of entity regulation have been taken very much into account, because much of what has been discussed here is really much more viable through the systems that an entity can impose. It grants the consistency and the support for compliance. In fact, I think some of the systems that are currently in place in firms assist the practitioners to comply with the individual code of conduct we have now, the rules of conduct. And this would be, I think, a much more helpful way of ensuring compliance.
Just to reinforce what the Treasurer said, I mean, some of the standard kinds of ethical considerations that practitioners need to have at top of mind, like file management, trust accounting, conflict of interest, well, all of these are firm systems. It's in a firm of any size, an individual doesn't decide what the system is. And so clearly, if there's going to be proactive improvement, it's going to be through the entity.
Thank you, Raj. Oh, well, I wondered if I might turn to Ross as a member of both the Task Force on Compliance-Based Entity Regulation and the Alternative Business Structures Working Group to address the next question, which was, how does this initiative dovetail with the Law Society's work to evaluate alternative business structures in Ontario?
I'd answer that by saying not really any at all. The Alternative Business Structures Working Group, which released its report last September, is looking at an aspect of alternative business structures that is much more focused and narrow than had been originally the case. And that study is going ahead completely independently of the task force study. So I don't see any link between the two at all. In fact, I think that's the answer to the question. I don't see any link at all. And I would also correct you that I'm not on the Alternative Business Structures Working Group
my apologies.
any longer. Yes,
Okay,
thank you
for clarifying that. Gavin, I wondered if I might ask you to respond to this question, which was, how will the Law Society of Upper Canada pay for implementation and oversight of this new system? And the participant is pointing out that in England, the Solicitors Regulatory Authority charges law firms a percentage of their annual turnover or gross income received in a given year to fund entity-based compliance regulation. And so the participant asks, what thought has been given to the issue of how the system will be paid for?
Well, I think at this point the task force has only considered that in very general terms. That's another subject that we're going to be asking for input on as part of the consultation process and thereafter, if the system is adopted in the way that it's suggested in the consultation paper or in some other form. I mean, ultimately, the hope would be that the regulatory costs would be no higher than it is currently, and ideally would be less than it is currently, because we hope that one of the main budget items, one of the largest budget items that we have, is our complaints and discipline process. If this system were to be put in place and were to work, the hope would be that complaints would be very significantly diminished and that we would be spending less money than we are now on the reactive approach that tends to dominate the way the Law Society currently operates.
Could I just add a thought to that? And that is that we've learned on this task force that it's very dangerous to compare what's going on in other jurisdictions. Really, it's not apples and apples. And so I won't go into detail, but I can tell you that the system that's in place in the United Kingdom is quite different from what our task force has looked at. And if the questioner were to review the questions which are posed in our discussion paper, would realize that we're not talking about a prescriptive system with heavy regulation and rules such as they have in the United Kingdom. So he's fallen into the error which I myself had at the beginning of this study, which is to think that what happens in another jurisdiction might necessarily be transferable here. Simply not the case.
Thank you. I wondered if I could ask the Treasurer perhaps to address this next question, which came to us from Nova Scotia, as a matter of fact. And the question is, what process might the Law Society of Upper Canada use to identify appropriate tools or resources that could be helpful to particular entities or practitioners?
We certainly would like to hear from practitioners what kinds of tools they think they need. We also, of course, would have input from our own staff on the kinds of tools they view as helpful when they're doing practice audits, for instance. What are the kinds of tools that they think would most help practitioners? And as I say, there needs to be a dialogue on that. And again, we'd look to other jurisdictions too. So I think all sources would be examined, and we determine what we thought would be the best.
Thank you, Treasurer. Raj, I wondered if I might direct this next question to you. The participant has asked, would the implementation of compliance-based regulation not add to the problem of non-transparency? Many practitioners believe that they are complying with the rules of professional conduct only to be told later that they are not. Does this not increase uncertainty when it comes to compliance?
It's hard to give a categorical answer to that, but as a general proposition, I think proactive systems are designed to increase certainty and increase transparency, in the sense that they are designed to provide greater guidance to the professions as to what their obligations are and what the Law Society will expect of them and what the public should expect of them in terms of ethical standards. And so from that standpoint, I would have thought that it is more transparent and likely to be more useful than waiting for a complaint and potentially going through a rather difficult for any practitioner system and perhaps ending up with a decision that has to decide whether the conduct in question was contrary to the rules of professional conduct or not. So I would guess that this is likely to increase transparency and certainty.
Thank you, Raj. I've had another question from someone who's asked whether the Law Society of Upper Canada would make a checklist available to individuals who are having to, for example, experience an audit or perhaps fill out a self-assessment tool or other document similar to one that you were describing.
Yes, well, the system that's already in place, as elaborated on in our discussion paper for practice review, for example, involves the provision of a checklist to the firm, or I guess the person in this circumstance, who's submitting to the practice review. And so there's already a template in place. It's one of the proactive measures that the Law Society now uses. So I can't see why we would step back from that if we were to implement the compliance-based entity regulation. One aspect of virtually every compliance-based entity regulation system that we've looked at around the world has been a self-assessment tool of some kind, not unlike the practice management or practice review checklist, I should say, not unlike the CBA checklist, which is referred to in the paper and is available for anyone to see. So we would certainly provide something, but the that aspect of our mandate is sort of yet to come when we take the input that we hope to receive as a result of this process, formulate recommendations to convocation. Presumably it would include some aspects. As Mr. McKenzie mentioned, it will have to address costs, implementation time periods, as the Treasurer mentioned, and also how we're going to implement it, which I'm certain will include a self-assessment tool, which we haven't yet designed because, of course, we haven't even decided whether we're really going to implement this practice. So I hope that helps.
Thank you, Ross. I wondered if I might direct this question to Gavin, which came from a participant this evening who's asking whether this type of regulatory scheme could address an issue such as advertising by law firms.
Yes, I'm trying to think which of the principles that would be applicable to, but the principles include best practices for clients, for example. The Law Society is currently looking at that troublesome problem of advertising. There's a lot of discussion in the profession about it generally, and it's a troublesome problem. I don't see entity regulation particularly being a solution to it. I think that's probably one that we're going to have to address by looking at the rules of professional conduct again, whether they should be amended, and enforcing the rules of professional conduct which prohibit misleading advertising, etc.
Thank you. Well, that, in fact, is a great segue into another question which was asked from someone earlier this evening who wanted to know how the rules of professional conduct would evolve over time if such a system of regulation were to be implemented. And I wondered if you might want to comment on that, or perhaps if others wanted to offer some thoughts.
Yeah. I think that's very unpredictable. We obviously would need to and would want to continue to have rules of professional conduct, sending out ethical principles and guidance in the form of commentaries, ethical principles and rules that can be enforced through our discipline process. The hope, again, would be that we would be resorting to the discipline process only as a last resort and only in unusual circumstances. One thing I think I might add would be that the entity feature of this is common in other professions, that we've looked not only at legal profession regulators in other jurisdictions, but we've looked at regulators in other professions. The Securities Commission, for example, regulates not only registered representatives but also firms, and has had success. And there are many cases where it's fair to impose responsibility on the entity, something that we're not able to do now, rather than on an individual practitioner. We've discussed quite frequently on the task force, for example, quite a high-profile case dating back a number of years now, where every member of the management committee of a relatively large firm at the time was charged with professional misconduct because of what was seen as being late reporting of the misconduct of a partner in the firm. I think that might be an example of a case where it would be more appropriate to fine the law firm, for example, rather than to reprimand or suspend the members of the management committee for a majority vote that took place at that level. So we certainly wouldn't be doing away with rules of professional conduct. We would be enforcing them, we hope, less frequently.
Thank you, Gavin. Yes, please do, Treasurer.
Yeah, I think we would expect that the compliance-based approach would enhance the ability of individual practitioners to fulfill their obligations under the rules of conduct. So that while they probably would evolve, I would see them as being complementary.
A question that I'd like to direct to Raj, if I may, and the participant was asking how long the task force had been working on this issue.
It was appointed in June of 2015. and has met at least monthly and probably more than that.
Umpteen times.
Umpteen times, in the words of the chair.
Thank you, Raj.
Could I add to that, though?
Of course.
I wouldn't want to leave the questioner with the impression that the Law Society had not been looking at this issue until June of 2015. In fact, the establishment of the task force was the result of deliberations by the Professional Responsibility Committee going back 2-3 years, I think, and a number of staff reports that came forward to that committee and ultimately to convocation over a period of 18 months or 2 years, as a result of which the task force was established in order to study it in a more focused and time-focused way.
And I might just add that, of course, we've looked at other provinces, and other provinces have had this authority in one form or another going back now 11 years. And so these issues have been percolating for some time, and clearly our Law Society, as the largest one in Canada, has had these issues under its consideration before the task force was formally set up.
Thank you, Raj. We had a question from someone who was asking about CPD hours, and I was wondered if I might suggest to that person they should probably direct those inquiries to the Continuing Professional Development Department, that there is a CPD credit available for this program for your substantive hours. I don't know if there's anything anyone wishes to add in terms of the possible impact on CPD hours of this initiative. It's really, I think, probably quite premature to speculate on that. We had another question about whether the task force had intention to regulate entities in the exempted category, and I wondered if what the participant might mean was the in-house counsel and other practitioners that we touched on earlier who are not currently subject to regulation, that will be more focused on private practice. And I suppose the response would be that as you had indicated earlier, Gavin, that's a consideration that perhaps would come later, depending on Convocation's views.
Yes. No, I think that's true. We again, as our chair said, we welcome input on that now. The principles that are mentioned in the consultation paper to a greater or lesser degree will be applicable to lawyers who work in other organizations and who do not work in private practice. But we don't intend to propose to Convocation as a result of this consultation process that in-house counsel be regulated at this time in the same way.
Thank you. I had a question that I wondered if I might direct to Ross, and that is the participant has commented that it's easy to say that one size does not fit all and that implementation will be flexible and entity-specific, but aren't there limits to that? As a practical matter, says the participant, unless you have consistent implementation, how can the Law Society of Upper Canada realistically monitor compliance?
So the objective, again, and I tried to address this when I was speaking about the definitions at the very beginning of the webcast today, is that it's flexible, it's autonomous. The principles that are proposed for discussion, and which may or may not be the final version if indeed compliance-based entity regulation is ultimately adopted by Convocation, are just that, they're principles. And they can be met in a whole variety of ways, which will look different for a small firm than a large firm, which will look different from one practice environment to another, which will probably look different as between a paralegal firm and a law firm. And so the question seems to come from a misapprehension about the rigidity of the program that's under contemplation. It's anything but rigid. It's completely flexible. And so it can be, it's described in some circles as a very light touch. And the idea, again, is to be looking at ethical infrastructure, practice management skills, basically to improve the ability of practitioners to carry on the practice of law in an ethical and efficient way, which will benefit the public, will benefit their bottom line, and will achieve the objectives of the Law Society. So I hope I've answered the question.
Thank you, Ross. We had another question from a participant who's asking, and I wondered if I might ask you to address this as well, whether there were any specific examples from other jurisdictions of what new forms and procedures may be implemented. So perhaps I think this participant might be getting at is examples from Nova Scotia of the self-assessment tool, the management system for
Yes.
ethical legal practice.
I mentioned before the CBA self-assessment tool, which is a similar model. But the jurisdiction in Canada that has probably been studying this issue the longest and has gone furthest towards its implementation is Nova Scotia. And I would suggest to the questioner that he or she might want to look at their website, where they have a great deal of information about the program that they have in mind. What I would like to say about it is that it's quite different from the aspects of compliance-based entity regulation that we're looking at. It's a much more comprehensive program. It's completely changing the regulatory environment in Nova Scotia, and that's not what we have in contemplation at all. So as far as examples go, they're the ones we've turned to the most in Canadian jurisdictions, because they're the ones that have actually developed some templates and examples, as I say, aside from the CBA paper. So I hope that's of some assistance.
Thank you, Ross. I wondered if I might actually direct this question to Raj, and the question is in French, and it is, quelles sanctions le barreau pourrait-il imposer à une entité ou un cabinet s'il y a une mesure disciplinaire? In other words, what kinds of sanctions might be implemented against a firm?
Ça va être décidé. C'est à cause de ça qu'on a cette consultation pour ramasser les avis de la profession et de les considérer. Comme le président a dit, on souhaite un système dans lequel le barreau fonctionne et travaille avec la profession afin que la discipline soit la dernière option.
Merci. Treasurer, I wondered if you might like to comment on this next question, which came from someone who's asked whether we could provide examples of the types of misconduct that led the Law Society of Upper Canada to become interested in pursuing the study of compliance-based entity regulation.
I can give some examples of conduct which result from poor practice management, but I do want to emphasize that that is not the only reason that we're looking at compliance-based entity regulation. We're looking at it because it could enhance the ethical infrastructure of all firms, whether or not we're getting complaints about lawyers there, and generally, hopefully, regularize many of the best practices that are already in place. Examples of poor practice management can result in failure to communicate properly with one's clients. Poor practice management can result in not being aware of conflicts and therefore leading to problems in that area. Can result in poor handling of monies or trust funds, and when clients are billed, when trust funds are accessed for billings, frequently, at least in my earlier experience when I was sitting on panels, it was before convocation panels, resulting from practice problems, not from dishonesty per se at all, but from practice management issues.
Thank you, Treasurer.
Could I add to that the discussion paper itself contains some statistics that might be of assistance to this questioner. Under the heading, The Emergence of Proactive Regulation, And it demonstrates there that, as the Treasurer just said, 52% of complaints received by the Law Society related to client services. And the task force also consults with and takes information from LawPro, the Lawyers Professional Indemnity Company. And their statistics are very similar. And they show that things like communications and reporting to clients is the basis of the majority of the complaints they receive on the negligence side. So both disciplinary complaints and complaints about negligent service seem to suggest that an enhancement of practice management skills is a very desirable thing.
Thank you, Ross.
Margaret, could I just add something to that?
Yes, of course.
And actually, I have the screen in front of me so I can see that there was another question which sort of relates to this,
Yes.
and that was that the point has been raised that by being proactive rather than reactive will save the Law Society money by reducing complaints and discipline. The number of complaints may be reduced, but will entity regulation reduce the incidence of lawyers who misappropriate trust funds or engage in professional misconduct that warrants disciplinary action? Law Society will always have the cost of reacting to misconduct. And I wanted to address it in this context because, first of all, to make the point that it's the profession that pays for the investigation and the prosecution of misconduct, obviously. And so, as the chair said earlier, it's intended to be, if this goes ahead, a win-win-win situation involving the public, the profession, and the Law Society. But more importantly, I think the question makes clear that this is not a panacea that's going to remove all misconduct in the profession. That is something which will require disciplinary sanctions in order to protect the public. But the goal is to improve systems, to reduce and to require practitioners to address these issues consciously, so that policies and practices and systems don't drift into a situation where intentionally or unintentionally they result in ethical lapses.
Thank you very much, Raj. There was another question that I wondered if, Gavin, you might like to address, and that came from a participant who was commenting that being a designated practitioner could actually be quite onerous. And he was referring to the possibility that as a designated practitioner, one might receive quite a bit of grief from one's colleagues. And I wondered if you wanted to comment.
Yeah, no, that's something that we've discussed at length on the task force. We do think it's probably necessary if we establish a system such as this, whereby we're regulating not just individual practitioners but entities, that somebody be designated in the entity, the law firm, to receive complaints, for example, and to ensure that the practice management principles, etc., are in place, and to report to the Law Society that that has been done. As a practical matter, we do that now in the area of trust account reporting, for example. Everybody who practices in a firm knows that when they fill out their members' annual report, they will refer and incorporate by reference the response of a designated member of the firm, typically the managing partner, who will report on trust account compliance, for example. We do recognize that it's essential that we carefully define the responsibilities of the designated practitioner in such a way that it's not so onerous a responsibility that nobody would ever want to do it.
Yes.
Now, it doesn't necessarily have to be the managing partner. It can be another member of the firm. Many large firms now, for example, have general counsel, and that may be a logical person to be the designated practitioner. In a smaller firm, a two-lawyer firm, it could be either one of the two. But we do think it's necessary to identify a designated practitioner who's the contact person for the Law Society insofar as the entity is concerned, and at the same time avoid imposing such a burden on that person that it's a disincentive to take the responsibility on.
Thank you, Gavin. There was a question that came in that I wondered if I might ask you to comment on, Ross, and that was from someone who asked how the Law Society of Upper Canada would go about developing the tools and the templates that might appear in a self-assessment tool if one were to be developed?
Thank you, Margaret. Well, that's sort of beyond the horizon a little bit,
Yes.
because at this point we're seeking input as to whether we ought to implement such a system at all. But as I said earlier, a self-assessment tool is a common feature of every compliance-based entity regulation system at which we have looked, whether it's in Canada or elsewhere in the world. And so we would obviously look to those precedents as well as our own resources in order to develop a template for a self-assessment tool. As I mentioned earlier in answer to a question or a comment, I have observed the iterations of the self-assessment tool that the Nova Scotia Barrister Society has worked on, and I have seen how it's developed and evolved as time has gone by to the present one that is now being subjected to comments from the professions in that jurisdiction. But we have the practice review checklist already, and it's very similar to a self-assessment tool, albeit it's used in a slightly different way. We have the CBA self-assessment tool, which is another example. And so, we won't be reinventing the wheel. We'll be looking at what works in other jurisdictions, and those that have gone before will assist us a great deal. That said, obviously we're going to come up with a self-assessment mechanism that will be appropriate to the principles and objectives that our law society would adopt, if any, and also we're going to build on what we've already got in the system, as it were. So I don't think it's going to be a particularly onerous task, but it's going to be custom-made for our jurisdiction.
Thank you, Ross. Raj, I wondered if I might ask you if you'd be kind enough to let me know if there were any other questions that we didn't yet have an opportunity to address, because we seem to have experienced a bit of a technical difficulty at this end.
I've been
in terms
experiencing
of receipt
that.
of questions.
I've been experiencing that actually at this end as well, but every once in a while my finger manages to scroll the screen down. There was a question asking whether there would be a review of this initiative after implementation if it goes forward.
Treasurer, would you like to comment on that, perhaps?
I think that's something that would be considered if and when the matter goes to convocation. I can say that convocation frequently asks for periodic reviews of programs, and this strikes me as one that would very likely attract that comment.
Thank you.
There was another question which I think is a good one, and others may wish to address it. The consultation paper indicates that 54% of complaints arise from sole lawyers, and 73% of 2014 complaints involve sole paralegal practitioners. How is this addressed by entity regulation? It seems lawyers practicing in entities are not the problem. Would it not be better to focus compliance-based efforts on sole practitioners?
Interesting. Mr. Chair, would you be interested in addressing that?
Want me to address that one? Well, let me go back, first of all, by saying that one has to be cautious, as I said earlier, about comparing apples and apples. But we do have some experience of two jurisdictions which have implemented a compliance-based entity regulation system. And the one that's perhaps most appropriate to the questioner is the one in New South Wales, Australia, where, and I've forgotten the exact statistics, some of them are in the discussion paper, but most of the entities there are what are called incorporated legal practices, and the majority of them, in turn, are solo and small practitioners. And and they have about a dozen years of experience at this, and what they have found is that the use of the self-assessment tool, which requires the professional to contemplate the principles which are enunciated in that jurisdiction, in itself has caused a substantial reduction in the number of complaints. I think it's 2/3 in that jurisdiction, 2/3 in the number of complaints. So if I put that together with the fact that most of the incorporated legal practices are solo and small practitioners, I cannot help but conclude that at least in that jurisdiction, it's had a dramatic favorable impact on the number of complaints. So their definition of entity regulation includes, I want to call them ILPs because that's what we've learned to call them on the task force, incorporated legal practices.
Yes.
And so that's one of the incentives for us to ask the question to the professions as to whether we ought to include solo and small practitioners in this initiative. It being our thinking that it would be a beneficial thing, as I said earlier, not only to improve practice management, ethical practices, reduce complaints, increase client satisfaction, improve the services to the public, but also to provide guidelines that will be helpful to solo and small practitioners who are otherwise wrestling with this very disciplined process that Mr. Anand mentioned, and that is most unfortunate for some who find themselves embroiled in it.
Yes, thank you.
There's another question which I guess comes back to I think our discussion of other provinces and the objective, not necessarily the necessity, but the objective of putting in place, if we do put this in place, regulation that would harmonize or be consistent with other provinces to the extent possible. So the question is, have you considered how this might apply to interprovincial law firms? In other words, will it only apply to firms' offices in Ontario? Which is obviously a very specific application of what I was just saying a moment ago.
Well, I can say that we have consulted with other law societies in Canada that are studying compliance-based entity regulation. And specifically, we've met with the Prairie provinces who are collaborating together in their study of it. We've met with the Law Society of British Columbia. We have visited the Nova Scotia Barrister Society and partaken in some of their deliberations, particularly surrounding the self-assessment tool I mentioned earlier. And everywhere we've gone, we have heard it expressed that there is a requirement, as the Treasurer said earlier, for there to be a harmonization of entity regulation and compliance-based entity regulation in every jurisdiction in Canada. Obviously of particular importance to firms which have offices in several jurisdictions or international law firms. I need scarcely explain why. So it's very much on the radar of every jurisdiction that's considering it. And that also, I might add, is the reason for taking a somewhat incremental approach to it, so that, as one of my colleagues in one of the other jurisdictions said, so that we don't get so far out in front that we're mistaken for the enemy.
I think I've run out of questions that I can access. I'm up to 618, so that's probably most of them. Yeah, I think we've certainly covered the last questions. Let me, if we have some time, let me ask this one as well, which was a little while ago I saw this. The consultation paper makes no mention of either class proceedings or a lawyer's special obligation to comply with human rights legislation. The CBA ethical practices self-evaluation tool that Ross referred to addressed, oh no. Sorry, it's back. Addressed lawyers and law firms respect and foster the rule of law and the proper administration of justice, close quotes, without specifically addressing either of the above two topics, which are class proceedings and human rights obligations. Currently, there's a void in Ontario class proceedings with respect to the regulation of a lawyer's ethical responsibilities, including their special human rights obligations under the Law Society rules to their clients, i.e. the class members? Are these issues that this committee might review? I'm not sure I understand the link myself, but let me just say this, that with respect to human rights obligations, as we've said earlier, diversity, inclusion, and similar topics which are obviously covered by the rules of professional conduct now and which are generally established through systems within law firms in terms of policies and practices and hiring and that kind of thing, are among the practice management principles that we've set out in the paper. And so those, certainly there's an intent, if this goes ahead, and subject obviously to the consultation that we have underway, to get input from the professions and others as to how all of those practice management principles, including this one, can be properly implemented. And as is stated in the paper, there's in fact consideration of these kinds of issues in a parallel initiative of the Law Society involving challenges faced by racialized lawyers and paralegals. With respect to class proceedings and the special obligations of class proceedings lawyers to class members, I don't know if there are others who might want to address that.
I think I'd just like to add that I think this question illustrates very well something that we were discussing earlier, which is how a system such as this would enable us to adapt the principles to a particular type of practice. A lawyer who has a plaintiff's class action practice or a practice that includes plaintiff's class action work, for example, will come up with an implementation plan that will differ very significantly from that even of another litigation lawyer whose practice is commercial litigation and does primarily defense insurance work or something along those lines. So, we would be requiring every practitioner, every entity, to direct their minds to each of the 7 principles, but the implementation plan will differ quite significantly depending on the size of firm, the nature of the firm, and the type of practice that the firm has.
Can I put forward one other? Your presentation, speaking to all of us, assumes that complaints against lawyers are valid. Has the committee considered how to stop the intrusion and expense on lawyers, especially family law lawyers, of fielding unwarranted complaints? I've had this experience several times, and each complaint was expensive to respond to in time and money, and each time the file has been closed. In some cases, my office was paralyzed for several days while we responded. Thanks. I might just say this, that obviously investigation and prosecution and adjudication of complaints is a significant part of the core responsibility of the Law Society, and it is one that the Law Society devotes a great deal of resources and a great deal of importance to. And so what this speaks to is one lawyer's experience, at least, in terms of the investigation process, and the investigation process is always under review and can always be improved, and certainly that's something which I'm sure the Treasurer would agree the Law Society will always be conscious of and looking out for.
Thank you, Raj. I wondered if I might actually just follow up on those themes and perhaps direct this question to Ross. And the question was, why are sole practitioners more at risk? And what might a sole practitioner do to avoid unnecessary complaints?
At risk of complaints, I gather?
Yes, that's right.
I think it was addressed, I believe it was by Mr. Anand earlier in the webcast, when he suggested that sole practitioners don't have immediately available mentors or colleagues in the same building or on the same floor next door with whom they can consult when a problem presents itself. And so absent that kind of guidance, which is available in the larger firm settings, a well-intentioned solo practitioner may well just make an error. And as the treasurer said in answer to an earlier question, the statistical evidence is that the errors that result in complaints either to the Law Society or allegations that come to the Lawyers Professional Indemnity Company arise more frequently in solo and small practices than elsewhere. I don't know that we can statistically identify the cause for it, aside from the speculation that Mr. Anand and I have just engaged in, but it would seem to be statistically proven that the majority of problems originate with solo and small practitioners, and the majority of the problems relate to practice management issues, such as client reporting, communications, and so forth, as opposed to competency. So I hope that's of some assistance.
Thank you, Ross. Now, we had another question here that also follows up on the distinction that you were just establishing between the role of the Law Society and the role of the Lawyers Professional Indemnity Company. The participant has indicated that the task force has stressed that sole practitioners experience a large percentage of the complaints made, as was just discussed. And then the person is asking whether there is any correlation between sole practitioners, small firms, and the size of claims that are paid out by the Lawyers Professional Indemnity Company. I don't know if, Gavin, that's something that you might like to address.
I don't know the answer to that specifically. I know that the type of work that large law firms do may mean that when a claim is made, their exposure may be larger. If you're working on a multi-million-dollar or billion-dollar merger, your exposure can be very significant. And it may be that a sole practitioner who works in an area primarily for individual clients has less exposure and that the claims are smaller in size. But I don't have statistical information to take that any further.
Thank you, Gavin. We had another question, Treasurer, from someone who was asking about whether or not the implementation of compliance-based entity regulation could address occurrences where there's a misappropriation of trust funds by a lawyer or other kinds of related professional misconduct.
Well, compliance-based regulation is looking at proactive systems which could prevent.
Yes.
If someone is determined to commit dishonesty, I'm not sure it can be prevented by a system. It may mean that it is more easily discoverable, or it may mean that it is more difficult to do. But that is why we would not abandon our rules of professional conduct because compliance-based regulation is not going to be able to prevent everything.
It may be that the entity will be able to discover
Yes.
A misappropriation or misapplication or other irregularity because of the responsibility we would expect entities to assume under this proposed system.
It may well be that as part of the systems they put in place in order to meet the practice management requirements, that they would be better able to detect such defalcations or irregularities in trust accounts.
Sooner, by way of preventing further or addressing something that's just happened.
Yeah.
Yes, thank you. I think that the point that this participant was trying to make, Ross, was that it would likely be the case that the Law Society of Upper Canada would always have to dedicate a certain percentage of its resources towards the handling of complaints.
I would agree.
Yes. I wondered if I also might ask Raj perhaps to comment on this question, which was, what documentation or information about an entity's compliance or ethical practices would be made available to the public by the Law Society?
Well, that is, I suppose, suggested or hinted at in the registration part, the question that relates to registration of entities. And questions are raised, and we're looking for input on this as to whether there should be registration, and if there is, what information will there be in relation to the entity, and one possibility is clearly disciplinary history of some kind. I mean, right now, any lawyer or paralegal's disciplinary history is on the website and is available to the public and is intended to be available to the public. So that is certainly a possibility.
Thank you. Now, we had a question from another participant who was asking, and I wondered if Ross might comment on this, how the Law Society of Upper Canada might respond if it were discovered as part of the completion of the self-assessment tool that there were some issues that were perhaps some areas in which the firm might not be compliant. And the participant was pointing out that the Law Society of Upper Canada would still have an obligation, of course, to go after, as it were, non-compliance.
Yes, I thank you for addressing this question to me, because it's one of my pet topics on this task force. The answer is that there would be a continuum of potential regulatory responses, and this has been addressed in some earlier questions as well. And only in the last resort would there be some sort of disciplinary measure taken. Again, I mentioned that there has to be a shift in the relationship between professionals and the Law Society if a system of this sort is to work. Therefore, the answer to the question depends on the nature of the problem that's identified by the self-assessment. So if it's a problem that can be addressed by, say, education, then the regulatory response might be to, via telephone or letter, suggest that the problem can be addressed by attending a CPD course. If it's a matter of accounting, trust accounting or otherwise, something like the present spot audit program might well be engaged, the purpose of which is primarily to educate the professional as to how to do it properly, not to discipline them for having made a mistake or been less than completely compliant with the regulations. It would only be in the most extreme cases that an entity might be subjected to sanction as opposed to assistance and aid.
Thank you. Now, but in some of the possible outcomes that you were describing just now, Ross, I think you may have touched on one of the questions, which was, well, what would assistance by the Law Society look like? And I think you have outlined some of the possible ways in which the Law Society might assist someone who contacted.
Yes, I mean, it's again, that's sort of over the horizon as well, but the concept is that we're moving from a system which is reactive, after the fact, disciplinary, to one that's proactive, upfront, and helpful. And so that's why I keep saying the relationship between the Law Society and the professionals will change in a system like this. The role of the Law Society will be much more to aid, assist, educate, help, and much less to discipline, except in those extreme cases where a sanction is simply required.
Thank you. Treasurer, I wondered if I might address this question to you. And the participant has asked, well, if there were entity regulation, would the public be able to search an entity through the directory that appears on the Law Society of Upper Canada website in the same way that they are currently able to search for information about a paralegal or a lawyer?
Well, if there's a registry system, presumably that could be searched to ensure that whether or not a particular group is registered as an entity. Beyond that, that remains to be seen as to how much more information might be available.
Thank you. We have another question that touched on the issue of alternative business structures, which I think was addressed earlier. And Gavin, I wondered if you would like to comment on this. Is entity regulation the first step towards alternative business structures, is the question that's being asked.
Well, I think Ross has answered that before. The answer is no. We have a group, as everyone knows, looking at alternative business structures that's made a report. Convocation has dealt with the subject. The focus here is on the proactive regulation in the sense that we've been discussing it. We haven't addressed. It's beyond the mandate of this task force, certainly, to consider alternative business structures.
Thank you, Gavin. There was a question, Raj, that was asked by someone who wanted to know how equity, diversity, and inclusion would apply to a sole practitioner who didn't have staff.
Yeah, it's a good question. The rules of professional conduct as they stand now, and the Human Rights Code, of course, which is essentially incorporated into the rules, say that every licensee, lawyer, or paralegal of the Law Society has a special duty to uphold the Human Rights Code and not to discriminate on any of the prohibited grounds. And that applies to staff within the workplace. It also applies to other lawyers in their dealings in court or in the course of interactions on a file. It deals with their interactions with the public. And in all of these cases, just to give you an example, a client may have special needs, and that can be a sole practitioner or it can be a member of a 200-lawyer firm. And so the Human Rights Code doesn't apply only to lawyers who are employed or partners or anything like that. It applies much more widely than that. It applies to the lawyer or paralegal as service provider or as employer or indeed as member of this law society.
Thank you. Now, we had a question as well earlier from someone who was asking about the practice management principles and noting that a lot of what has been discussed today by the task force are issues that are often raised during an audit, and there are sometimes issues that practitioners reflect on when they submit their annual report. So the question is, are you recommending, and I'm wondering, Ross, if you might address this, doing more auditing or more reporting to the Law Society?
No. I think that's the whole answer. As I mentioned before, at present, there are a number of proactive tools that are already utilized by the Law Society to assist practitioners. And these are spot audits, which this questioner mentions, practice review. And in those circumstances, while I rather expect that the practitioner who is on the receiving end of a notice that he or she will be subjected to an audit is at first apprehensive, as I said earlier, 96% of practitioners who are subjected to a spot audit or a practice review are very favorably impressed by the process at the end of the day. They've learned something from it, they've improved their practice management, they've improved their accounting management. Young lawyers are given tips and tricks as to how they might better deal with their clients, serve the public, respond to the regulator. And so, in my view, the presently existing tools may be subjected to less frequent application than at present. Because at present, it's something that we must do on a proactive basis in order to detect and address this kind of problem. And under a compliance-based system, the self-assessment tool presumably would trigger the designated professional to indicate that there is some issue or concern or problem that could then be addressed in this helpful way that I've described a couple of times tonight, rather than through ultimately a complaint or a disciplinary action.
Yes, Treasurer, please do.
I think some of the best practices that are urged upon persons when they are subject to a spot audit are extremely well received, and those best practices no doubt could form part of the self-assessment tool and some of the systemic approach that could be passed on and therefore more standardized and more regularized. I recall just a recent meeting when a relatively new practitioner said that the practice audit had been the best possible thing that the Law Society has done for that person's practice and her ability to practice. Very complimentary and very grateful for it.
You haven't.
And just to add to that, what's implicit, I think, in what both the treasurer and our chair have said is that it's natural enough, I think, for our practitioners, our members, to say to the Law Society, please get out of my hair. But when the Law Society is playing a proactive role, as we have with our practice review program, for example, and with spot audits, the reception has been very favorable. And I think rather than look at this as a fundamental departure, although there's this dichotomy between being reactive on the one hand and being proactive on the other, I guess I see it as more of an evolution. And something that we've already started through initiatives such as practice reviews, for example, to change the emphasis and move towards a more proactive approach generally, rather than a reactive approach, because we get a much less favorable reaction from our members to that.
I'm sorry. That's being done in other areas of our Law Society work as well, in terms of mental health issues. I mean, being proactive rather than people being subjected to discipline in circumstances in which they're not able to cope. Even within our tribunal system, we try to resolve cases to the extent possible, resolve issues. So there's a significant evolution, I think, that's only that can serve the profession better.
Thank you. There's another question that we've received, Treasurer, when it came from someone who was asking about the methodology that the Law Society of Upper Canada might use in determining which of the practice management principles would apply or which would not apply to government lawyers or corporate or in-house counsel. And I wondered if you might want to comment on that.
Well, that area has not been developed yet, so the methodology, I think, would be very much the same as we've applied here, and that is a certain amount of study, a look at best practices in those areas, consultation, most importantly, with those areas of practice to result, hopefully, in positive suggestions. Now, that's very much what we expected this task force to do vis-a-vis private practice, and I would expect the system would be very much the same.
Thank you. There was another question that I think has probably been touched on over the course of the evening, but I wondered if, Ross, you might like to address it. If a new practitioner needs some help or assistance in order to be in compliance, would the Law Society assign someone to look after their practice and offer suggestions?
I don't know that the Law Society would look after the practice, but it would certainly provide assistance.
Pardon me, I should have said look into the practice.
Oh, look into the practice.
Yes,
yeah.
Sorry.
I think there's a world of difference between,
That's right. There
between
certainly
those
is.
two words. Well, again, I want to go back to say, climb on my soapbox again and talk about the continuum of regulatory responses. It very much would depend on the nature of the problem that was identified. If it was simply a question of assistance with practice management skills, client relations, that sort of thing, communications, again, first there would be assistance provided. It might be in the form of a practice management review, which would involve a personal visit by someone from the Law Society, or it might be as simple as suggesting a couple of continuing professional development courses that could be taken to address the problem at issue. It's a complete change in an evolution, to take Mr. McKenzie's view, an evolution of the relationship between the practitioners and the Law Society that I've mentioned a couple of times tonight.
Can I just add to that in terms of his current initiatives, it might involve suggesting to the person that they take advantage of the developing mentoring initiative at the Law Society, which was just approved last convocation.
Yes.
Thank you. I think we may have, in fact, come to the end of the questions that have been received, but perhaps just to reiterate that anybody who does have a question that comes to mind is welcome to send it by email to the Law Society. Ross, I wondered, Raj.
I see a couple of other
Okay,
questions.
fantastic. Yes, I am again experiencing some technical difficulties, so please go ahead.
Yeah, no, this happens to be on my screen. Will the requirements be the same for part-time lawyers?
Yes.
And presumably part-time lawyers will be part of an entity in any event. Second, this is, I guess, a person in a university setting, I can perfectly see ways in which the stated principles and guidelines might help lawyers in public institutions, such as universities, in view of the multiple compliance and reporting obligations. One can see many uses to the self-assessment tools. I see this as a great initiative. Would the panel be able to comment on this? Well, I mean, we've addressed the in-house and public entities as being perhaps the next step at this point, but that's interesting because, of course, university lawyers and lots of individuals employed in universities do have a lot of different conflicting obligations, and there may be some significant ethical issues that need to be addressed.
Great.
Well, that's right. Yes, I wondered if I might turn it over to you now, Ross.
I would just add to that last response by Mr. Anand that we are looking for input from everyone, and that would include persons such as the questioner in that case. So we've reached the end of our webcast this evening. As chair of the task force, I'd like to thank my fellow panelists, Mr. Anand, Mr. McKenzie, Treasurer Janet Miner for their participation today, and a special thanks to Ms. Drent for serving as our chairperson. I would strongly encourage you to participate in the call for input. The task force is keenly interested in knowing your views, which will assist us in drafting our final report. Mr. Anand, did you want to say something in another language?
Le groupe vous remercie pour votre attention et votre participation, et si vous avez des commentaires, nous les accueillons. Merci beaucoup.
Thank you. That expresses my ineptitude in the French language, for which I apologize to our French viewers. Ms. Drent will now provide some further information about our initiative before we sign off.
Thank you, Ross. This webcast will be archived on the Better Practices page on the website of the Law Society of Upper Canada. So please, to all those who participated this evening, please let your friends and colleagues know if they weren't able to join in that they're more than welcome to check back on the page, and the recording will be made available within the next couple of weeks. And as we indicated earlier, if there are questions that any participant would like to ask, they are welcome to send them to the Law Society in the coming weeks, and the task force will endeavor to respond to those questions and to make the answers available on the Law Society webpage. With respect to the call for input itself, for those who wish to provide a submission in response to the call for input on promoting better legal practices, there are 3 ways that you can do that. And the first way is that you can submit your response online when you're reading the paper. The second way that you can respond is by email, and you can send it to my attention, mdrent, D like Douglas, R-E-N-T, at lsuc.on.ca. And the third way of responding is by sending a letter to the address that appears on the Better Practices webpage. So thank you very much, everyone, for your participation this evening, and good night.